I just wish to point out to your lordship's note that I have filed that written submission additional. It is in volume 8 at pages 28 to 30. Just your lordship may note where the judgments are concerned.
Volume 8.
Volume 8, page 28 to 30.
Yeah.
Great.
Thank you, Mr. Patwari.
My lords, yesterday when my lords had risen, I had finished point 6. Your lordships have my note. It's 2C now. Volume 2C. It's been uploaded. So, yes, 2C. My lord, the Chief Justice has it? 2C?
Yes.
Mr. Kumar? But, point 6, I had concluded by showing your lordship that section 14(2) of the Lokpal Act, which reproduces effectively the section 105 and its import. So whatever is the interpretation that your lordships give here will have an impact there as well. Sorry, my lords have it?
No,
Volume
sir.
2C?
It's not there, but all right, isn't it? You can display. 2C is not uploaded.
I'm sorry.
Display, you can display.
This displayed.
Well, I don't know if it's because it's interactive as well, the note, so. It's interactive as well, so it will be
Yeah.
helpful. If
No.
I'm not-
I can get it here.
Okay.
Display. It was emailed yesterday.
This Hori rising is supposed there are two judgments on point 7. Point 7 is, it is established that a strict interpretation ought to be given to laws dealing with corruption, which affects the public weal. But before I take your lordships to that para 5 at page 11, and maybe before it gets uploaded on Justice Sundaresh's system, I could take your lordships to volume 8. There are two judgments which I had alluded to yesterday in the context of section 197 of the CRPC. That was, of course, on the question of sanction, but obviously a similar interpretation would apply between a sanction which is a lower bar and an immunity which is much higher. It's at page 31 of volume 8. It's Horiram Singh versus the Crown. Volume 8, page 31. All your lordships have that?
Yes.
Volume- Yes. Now, this was dealing, my lords, with a situation where one Mr. Henderson had conspired before he fled to Britain to cheat the government out of certain payments that had to be made, and he falsified entries, etc. Interestingly, it was argued by Sir Brojendra Mittal, Advocate General of India, before the federal court. His portrait hangs in my friend the Attorney General's chambers. If your lordship will just come immediately to Justice Varadacharya, whose judgment everybody else agrees with, which is at page 55.
How do we take judicial notice of the portrait which hangs in the Attorney General's chambers?
No, it's just that because I in fact had visited the chambers when his predecessor was there, and we had the names of all the previous attorney generals with their portraits, and there were two portraits without names below, which were the two advocates general for India that we had prior to 1940. So one was Brojendranath Mittal. I think the other gentleman's name I forgot, but the names are not there. Maybe that can be repaired. But page 187, because 183 is where the majority starts. Just if your lordships can come to page 180, it's page, no, I'm sorry, I should have read the other page. Why the page number is not here? Huh?
What's the PDF page?
59, sorry. I'm sorry. Yeah, sorry. Page 59, I'm sorry. PDF is 59.
Yes.
At the bottom, that paragraph, if I can just read that. The reported decisions on the application of section 197 of the CRPC are not by any means uniform. In most of them, the actual conclusion will probably be found to be unexceptionable in view of the facts of each case. But in some, the test has been laid down in terms which it is difficult to accept as exhaustive or correct. Much the same may be said even of decisions pronounced in England on the language of similar statutory provisions. See observations in Booth versus Clive. It does not seem to be necessary to review in detail the decisions given under 197 of the CRPC, which may roughly be classified as falling into three groups, so far as they attempted to state something in the nature of a test. In one group of cases, it is insisted that there must be something in the nature of the act complained of that attaches it to the official character of the person doing. Judgments are cited. In another group, more stress has been laid on the circumstance that the official character or status of the accused gave him the opportunity to commit the offense. It seems to me that the first is the correct view. In the third group of cases, stress is laid almost exclusively on the fact that it was at a time when the accused was engaged in his official duty that the alleged offense was said to have been committed. The use of the expression while acting, etc., in 197 has been held to lend some support to this view. While I do not wish to ignore the significance of the time factor, it does not seem to me right to make it the test. To take an illustration suggested in the course of the argument, if a medical officer, while on duty in the hospital, is alleged to have committed rape on one of the patients or to have stolen a jewel from the patient's person, it is difficult to believe that it was the intention of the legislature that he could not be prosecuted for such offences except with the previous sanction of the local government. Two reported decisions, these are from the High Courts of Madras and Calcutta, one in Ganapati Gaundan under 197 and the other in Dakshina Ranjan Ghosh under 80 of the CPC, may be referred to as instructive, since in each of them, two acts were complained of, and notwithstanding the apparent connection between the acts in the sense of relation in time or opportunity, the court held that one of the acts was an official act but not the other. In the Madras case, a village magistrate held in confinement certain persons who were suspected to have committed a murder and also tortured them in order to extort a confession from them. He was charged for committing offences under 330, 343 and 348 of the IPC. Wallace J. held that sanction to prosecute him under sections 343 and 348 was required under 197 of the CRPC, but not for prosecuting him under 330. In the Calcutta case, a trader sued a police officer for recovery of two sums of money, namely 50 being damages for wrongful arrest and 75 being the amount alleged to have been extorted by the police officer from the plaintiff. As regards the second head of claim, the learned judges were of opinion that no notice under 80 of the CPC was necessary, as nobody could suppose that he was purporting to act in his official capacity in demanding and obtaining the sum of rupees 75. Just one quick follow-up, which Malod is at page 65. This is Satwant Singh. It's in 1960. It's page 64 of the same volume. Again, 5 judges judgment, where just one paragraph, if I can read, which is para 16 at page 70, bottom of page 70, 70. If I can read that, para 16, 16. Under section 197, no court shall take cognizance of an offence committed by a public servant who is removable from his office by the Governor General Council or a provincial government, save upon a sanction by one or other, as the case may be, when such offence is committed by him while acting or purporting to act in the discharge of his official duty. Henderson was charged with intentionally aiding the appellant in the commission of an offence punishable under 420 of the Indian Penal Code by falsely stating as a fact in his reports that the appellant's claims were true and that statement had been made knowing all the while that the claims in question were false and fraudulent and that he had accordingly committed an offence under 420, 109 of the Indian Penal Code. It appears to us, please mark this, to be clear that some offences cannot by their very nature be regarded as having been committed by public servants while acting or purporting to act in the discharge of their official duty. For instance, acceptance of a bribe, an offence punishable under 161 of the IPC at that time, before the Prevention of Corruption, is one of them, and offence of cheating or abetment thereof is another. We have no hesitation in saying that where a public servant commits the offence of cheating or abets another so to cheat, the offence committed by him is not one while he is acting or purporting to act in the discharge of his official duty, as such offences have no necessary connection between them and the performance of the duties of a public servant, the official status furnishing only the occasion or opportunity for the commission of the offence. The act of cheating or abetment thereof has no reasonable connection with the discharge of official duty. The act must bear such relation to the duty that the public servant could lay a reasonable but not a pretended or falseful, fanciful claim that he did it in the course of the performance of his duties. Vide Mata Jog Dubey. Now, if your lordship will come back to my note, my lords, 2C. Now, this position has been consistent in Prakash Singh Badal and elsewhere. Over 70 years, your lordships, 80 years, your lordship have followed this kind of reasoning as far as sanction is concerned. Now, the reason why I'm showing this parallel, my lords, is to comment to your lordships two fairly nuanced points. One is this, that in even the minority which we are relying on of Narasimha Rao, there might be one or two things your lordships may just look at again, because I would not believe that that is the correct position. Some aspects of the minority itself. So rather than embracing the minority in full, there are some aspects which may require some kind of clarity, including that arising out of whether you don't give a vote or a speech. Those aspects may require some clarity. But the second aspect is this, that when you interpret the entire cloak of 105 and the immunity that it gives, some distinction has to be made between the various types of activities. Now, in the recent judgment, my lords, which we had referred to yesterday also in Ajit, there was a distinction drawn between what are the legislative and non-legislative functions. Now, it is similar to what virtually every other jurisprudence that we could find comparatively have similar approaches with what is essential and what is part of your duties and where the immunity could lie and where it clearly doesn't and it can't be a part of. Now, if your lordships considers a scenario, for example, because this immunity attends not only proceedings in parliament, but also before committees. Now, those who are appearing before the committees, for example, are not only MPs and MLAs. They may be experts, they may be advocates, they may be people from civil society who have to weigh in, for example, on an environment bill. Or if there is an inquiry into ethnic violence somewhere and Parliament has a standing committee set up and people are coming in to make their statements. Now, if an MP or an MLA who is somebody who may be affected by that committee's findings against him or her were to threaten or intimidate or in any way detain, for example, that witness who's supposed to appear before Parliament. Now, those are all questions where the MP or MLA may say, this immunity is available to me because it's with reference to a proceeding of Parliament. So it shouldn't be that that cloak is available to that gentleman or that lady for that purpose. That is not the intention. The intention is that the minute it is a criminal act, that criminal act can only be immune if it is very directly related to the speech that is made or the vote that is given. It has to be direct. It has to be proximate in every sense of the term. It has to be there. So for that proximity to be obtained in a situation where I threaten or disable an individual from taking the legislative process forward, that is very proximate, because without that, the outcome may have been different. If I detain the balancing vote in Parliament on a particular issue, which may require a by-election to take place or a fresh election to take place, or whatever else it is, and I detain the person who's going to give the balancing vote in his house, I am interfering with the legislative process. Because if I had not done that, that person would have come and cast that vote. Similarly, if I had not detained the witness or intimidated the witness would have appeared before the parliamentary committee and made his intervention. So those are very proximate. And it has the test I would suggest is to see the consequence or the effect of that act. If that, I'm sorry, yes, ma'am.
To speak about the connectivity and context is one thing.
Yes.
The reformulating the scope and extent of the immunity is another thing.
Yes.
So what
Yes.
you are now suggesting, as against till now, what the arguments were,
Yes.
is that the crime was before
Yes.
the occurrence of the immunity.
Yes.
So therefore, it can be bifurcated. Now you would want us to also
Yes.
give certain conditions on the basis of which this scope of immunity is to be measured.
Yes, Manoj, because
Gets into a little difficulty.
I'll explain the reason why. Because, I mean, before 7 judges, these are not adversarial issues. These are issues that we all must be nuanced about. One of the contra arguments which is taken regularly, not only in this jurisdiction but elsewhere, is that if you have a powerful executive, and that powerful executive can then go after legislators and disable legislators if the legislators don't have that protective cloak. So when you have balancing this, you have to be careful of ensuring that the legislators get the immunity that the Constitution intended. That we can't run away from. We shouldn't make the cloak so small that it disappears. So if we are doing that, we have to have some kind of formulation or test on the basis of which we will say this immunity I think is fair and it is deserved. Now, and the immunity obviously will arise, as Mr. Ramachandran said yesterday, only when the crime is there. Because if there is no crime, there is no question of the immunity. The immunity is there is a crime, and then there is a question of immunity. So we take it that there is a crime, but what sort of crime? So the test here is to see what that sort of crime is, because otherwise, if there's no crime, there is no immunity. The crime which we are dealing with is a crime which attends a speech that is given, or as I argue, not given, a vote that is given or not given, as a consequence of something that is extraneous. There, the cloak will not arise if it is in the normal legislative process. Unfortunately, your lordships have seen a live example of this 2 weeks ago, when I don't know if the phrase parliamentary language can be used anymore after what took place. But we saw expletives being thrown around in Parliament. The gentleman who threw those expletives around, Parliament took care of ensuring that those words were struck off the record. But what took place was a crime. It's my view. My view is that what took place was a crime. It's many hues of hate speech and many provisions of the IPC would be attractive. But whether we like it or not, palatable or not, it is something he said during a debate, and he said it on a subject. I don't think it would be fair for us to say that that gentleman, however reprehensible his conduct may have been, did not have privilege when he said that.
So an action for criminal defamation will not lie on the basis
No,
of a
no.
speech.
In my view, very clearly, no.
Certainly not.
And that's what we're seeing. I mean, we are, our hands are tied. Obviously, we find this repulsive, but our hands are tied and the court's hands are unfortunately tied, because that is the deference that we give to the parliamentary process. It was not germane, but if your lordships were to embark on that inquiry on whether that word you said, this sentence that crept in, was germane to that debate or not, then we are treading on dangerous territory. I don't think we should be going that far. Examining a speech in a particular context and saying that these 2 sentences from the speech is actually constituting something else. But that's the international position.
Case to case basis.
I'm sorry.
Yeah, perhaps it's to go case to case basis. It's very difficult to lay down a
general
overarching
test.
proposition saying
No, that's
that far, no further.
no, I agree. So I'm just,
Now can the court say that, well, this was a speech.
yes.
These offending words which you used were unnecessary for the speech. That's not a part
That's
of
no
the
part.
court's
That's
obligation
no
or
part.
duty.
And we expect responsible parliament and parliamentarians to take much more stringent action. That's what we expect. We have come to expect. I'm not normally a conservative, but I feel that this is something that your lordship may look at. Now, I'll just come back to the note, my lords, quickly. If your lordships will just come to point number 7, which is at page 2. And if you'll just tap on that C para 5 at page 11. Just quickly, the very relevant extracts are there. This is page 11. My Lord Justice Sundaresh has the note.
No, I'm getting it.
Oh, it's there. Page 11. Just keep checking from here if it's there. Page 11, the first one under 5 is the Subramaniam Swamy case that was under section, I'm sorry, page 11 of volume 2C. It's on the screen also.
I got it.
So this is in the context of section 6A of the Delhi Special Police Establishment Act, what was struck down in Vineet Narayan as a single directive. the section provided an additional layer of protection to certain classes of officers, etc. And these are the observations of a unanimous constitution bench there. Para 59. Irrespective of their status or position, corrupt public servants are corruptors of public power. The corrupt public servants, whether high or low, are birds of the same feather and must be confronted with the process of investigation and inquiry equally. Based on the position or status in service, no distinction can be made between public servants against whom there are allegations amounting to an offense under the PC Act. Next para, only the underlined portion. There is no rational basis to classify the two sets of public servants differently on the ground that one set of officers is decision-making officers and not the other set of officers. If there is an accusation of bribery, graft, illegal gratification, or criminal misconduct against a public servant, then we fail to understand as to how the status of offender is of any relevance. Where there are allegations against a public servant which amount to an offense under the PC Act, no factor pertaining to expertise of decision making is involved. Yet section 6A makes a distinction. It is this vice which renders 6A violative of Article 14. Then page 12, para 72, the bold portion. The status or position of public servant does not qualify such public servant from exemption from equal treatment. The dissent of Justice Prasad and Rameshwar Prasad. But after getting elected, if the candidate deviates from the course of fairness and purity and becomes a purchasable commodity, he not only betrays the electorate, that trust which we had discussed yesterday, but also pollutes the pure stream of democracy. If your lordships will come back, my lords, to the top, there's back to top at the top of each page. So if your lordship just comes back, it'll take you back to the note. Next proposition, that's proposition 8, that's on page 3. The effect of the Rao majority is that it creates an illegitimate class of public servants that are afforded an extraordinary protection, which would be a violation of Article 14 as also being manifestly arbitrary. If your lordship will tap that, it'll take you to page 13. Well, at the end of each of these extracts in pages 5 to 18.
So some of your hyperlinks are not come. उधर देख लो hyperlinks क्यों नहीं आ रहे हैं?
The hyperlinks are not coming on that. आपके में आ रहा है ना?
Is it working?
The hyperlinks.
Maybe yours is converted to.
It's not coming any of yours.
No.
The hyperlinks, it's coming.
Oh,
What,
I'll just
some
check it out.
system.
That's okay. I'll check it out. Yes. Item 8, no?
Yes,
Point 8.
page 13 I was on.
Yes.
Yes, from 8 if you go, it will take you to page 13, top
Yeah.
of page 13. Creating a class of public servants, MPs, MLAs within the broad class of public servants is a violation of Article 14. This is the super citizens, which even Brewster refers to and Narasimha Rao refers to. Justice Khanna in Indira Gandhi. This court rejected that contention and held that the true constitutional position is that so far as a valid order of detention is concerned, a member of parliament can claim no special status higher than that of an ordinary citizen, and that he is as much liable to be arrested and detained under it as any other citizen. In the special courts bill, Malons, Justice Chandrachud speaking for the majority, at para 4, the underlined portion again, it only means that all persons similarly circumstanced shall be treated alike, both in privileges conferred and liabilities imposed. Equal laws would have to be applied to all in the same situation, and there should be no discrimination between one person and another, if as regards the subject matter of the legislation, their position is substantially the same. And finally, this Lokayukta Justice Ripusudan Dayal, the bold portion there, the basic premise for the privileges enjoyed by the members is to allow them to perform their functions as members and no hindrance is caused to the functioning of the House. The Committee of Privilege of the 10th Lok Sabha noted the main arguments that have been advanced in favor of codification, some of which are follows, and this extract. The basic law that all citizens should be treated equally before the law holds good in the case of members of parliament as well. They have the same rights and liberties as ordinary citizens, except when they perform their duties in parliament. The privileges, therefore, do not in any way exempt members from their normal obligation to society, which apply to them as much and perhaps more closely in that as they apply to others. And the next page, that last bold line, no one enjoys any privilege against criminal prosecution. Now, this is a consistent position that your lordships have adopted. Final point is the legal position in USA, UK, Canada, Australia, South Africa, and New Zealand supports the minority opinion of Rao, and the same is commended for this court's consideration. This includes an undisturbed line of cases following the majority decision in Brewster. If your lordships were to see at page 14, the extracts, the first is the United States. And this, we have, the extract is there of Article 1, Section 1, Clause 1, which is known as the Speech and Debates Clause, that the senators and representatives shall be privileged for any speech or debate in either house. They shall not be questioned in any other place. The full language of it, my lords, will find in that relevant annexure, Annexure 11. But the relevant parts of Daniel B. Brewster in the majority opinion are these bold portions. I'll just read the small parts of it. A legislative act has consistently been defined as an act generally done in Congress in relation to the business before it. Next, in no case has this court ever treated the clause as protecting all conduct relating to the legislative process. Third one, but no more than the statutes will apply was its purpose to make members of Congress super citizens immune from criminal responsibility. This is where the phrase super citizens comes. And the next one, which is not bold but relevant, para 50. The sweeping claims of appellee would render members of Congress virtually immune from a wide range of crimes simply because acts in question were peripherally related to their holding office. Such claims are inconsistent with the reading this court has given, not only to the speech or debate clause, but also to the other legislative privileges embodied in Article 1, para 6. Next page, page 15. There is no need for the government to show this para 62. There's no need for the government to show that appellee fulfilled the alleged illegal bargain. Acceptance of the bribe is the violation of the statute, not performance of the illegal promise, similar to us. Taking a bribe is obviously no part of the legislative process or function. It is not a legislative act. Now, this is followed in the judgments of Gravel, McCrade, Renzi, and the extract here, and Menendez. Here we have taken out the extracts only of Gravel and Menendez. The entire details you'll find in Annexure 11. White's opinion, speaking for the court in Gravel, is legislative acts are not all encompassing. The heart of the clause is speech or debate in either house. Insofar as the clause is construed to reach other matters, they must be an integral part of the deliberative and communicative processes by which members participate in committee and house proceedings with respect to the consideration, passage, or rejection of proposed legislation, or with respect to other matters which the Constitution places within the jurisdiction of either house. While the speech or debate clause recognizes speech, voting, and other legislative acts as exempt from liability that might otherwise attach, it does not privilege either senator, or aide to violate an otherwise valid criminal law in preparing or implementing legislative acts. Now, Brewster has been consistently followed in the US. The latest case is this 2016, which is Menendez. And there are these two paragraphs, specific sentences. Opinion of the court is Justice Ambrose. First, we look to the form of the act to determine whether it is inherently legislative or non-legislative. Some acts are so clearly legislative in nature that no further examination has to be made to determine the appropriate status. Examples of manifestly legislative acts include introducing and voting on proposed resolutions and legislation, introducing evidence and interrogating witnesses during committee hearings, subpoenaing records for committee hearings, inserting material into congressional record, and delivering a speech in Congress. On the other side of the spectrum, some acts are so clearly non-legislative that no inquiry into the content or underlying motivation or purpose is needed to classify them. Examples include legitimate constituent service, such as the making of appointments with government agencies, assistance in securing government contracts, preparing so-called newsletters to constituents, news releases and speeches delivered outside the Congress, and of course, illegitimate activities such as accepting bribes in exchange for taking official action. This is echoed, my lords, in your lordship's judgment in Ajit, and I would commend that this be the test that your lordships will apply. That if it is an illegitimate, your lordships can see the three categories here which the US Supreme Court has adopted. One is manifestly legislative acts, the second are clearly non-legislative, and the third is illegitimate activities. What Narasimha Rao's majority has done is taken illegitimate activities and said, no, even they had received the cloak of protection. And I don't think that was intended. Well, the rest of it is, and I'm sorry, bottom of page 16. 16 deals with the UK. Just the Joint Committee on Parliamentary Privilege. This is a report of 1314. if I can just read the bold portion. Requesting or agreeing to receive a bribe are now statutory criminal offences, irrespective of whether or not the acts for which the bribe was sought or offered are actually carried out. This makes the situation in the United Kingdom analogous to that in the United States, where the case of US versus Brewster established that a senator could be prosecuted by demonstrating that an unlawful agreement was entered into without the need to show that the bribe led to specific conduct, which may be privilege. Similar views in Australia. In Canada, my friend the amicus read R versus Bunting. We have also extracted the criminal codes in each of these countries, my lords. And for a minute, if your lordships would just go to, Annexure 8, which is page 112. I'm not going to read it. I'm just going to explain how we have split it up. Page 112, that's Annexure 8 of this one. Annexure 8. Your lordship will see that first page, page 112, deals with United States. So we have put the statute, the relevant statute or the clause of the Constitution at the top, and the relevant clauses of other related laws. Then the case name on left, the facts, and the extracts of the opinions, majority, minority, whichever is relevant, including highlighting in red what we would want your lordships to consider. In this light, before concluding, I just want your lordships to look at, and there are others to argue, so I'll just mention the paras. In Narsim Rao, if your lordships will kindly just see para 45, 47, 50 and 52. Now, these are parts of the majority judgment, minority judgment. 45 deals with the fact that a punishment by the House is not satisfactory. 46 is the interpretation of in respect of. 47 deals with the question of the vote or the speech already having been cast. And the question of something already having taken place is only where the words can be read as arising out of, where it has already taken place. There is one small issue there. If your lordship sees page 752, volume 5, page 752. Last sentence there on that page, which is part of para 47, if I may read that, the immunity, or the second last sentence, 4 lines up, the immunity from liability, therefore, comes into play only if a speech has been made or vote has been given. The immunity would not be available in a case where a speech has not been made or a vote has not been given. But I would feel that this is problematic, and this would not be the correct position, despite it being in the minority. Then the next page deals with that distinction and how our founding fathers did not mean for a distinction between what eventually took place, between those who voted and those who did not vote in a specific fashion. And para 50 deals with when the offense is complete, because that aspect was also considered. And para 52 says that the criminal liability for taking the bribe was independent completely. These other paragraphs, which I've mentioned, I think should be the correct position and should be followed, my lords. If your lordship will just now come to the judgment in Ajit, which is in volume 5, starts at page 2680, my lord. 2680, and I just want to read 2 specific parts of it. The first is para 74 to 75, which is at page 2704. Volume 5, page 2704. May I read that? All your lordships have it?
Volume para?
Para 74,
Yes.
it's page 2704.
Yes.
Privileges and immunities are not gateways to claim exemptions from the general law of the land, particularly as in this case, the criminal law which governs the action of every citizen. To claim an exemption from the application of criminal law would be to betray the trust which is impressed on the character of elected representatives as the makers and enactors of the law. The entire foundation upon which the application for withdrawal under 321 was moved by the public prosecutor is based on a fundamental misconception of the constitutional provisions contained in 194. The public prosecutor seems to have been impressed by the existence of privileges and immunities which would stand in the way of the prosecution. Such an understanding betrays the constitutional provision and proceeds on a misconception that elected members of the legislature stand above the general application of criminal law. The reliance placed by the appellants on P.V. Narasimha Rao to argue that the action of the respondent accused inside the House was a form of protest, which bears a close nexus to the freedom of speech and thus is covered by 194, is unsatisfactory. The majority in Narasimha Rao dealt with the interpretation of the phrase in respect of and gave it a wide import. At the same time, the majority observed that there must be a nexus between the act or incident, which in that case was the act of bribery in the context of votes cast on motion of no confidence, and the freedom of speech or to vote. It was emphasized that the bribe was given to manipulate the votes of the MPs, and thus it bore a close nexus to the freedom protected under Article 1052. The case, however, did not deal with the ambit of the privilege of freedom of speech provided to the members of the House. It was in Lokayukta Justice Ripusudan Dayal that a three-judge bench of this court laid down the law for the identification of the content of the privileges. It was held that the members shall only possess such privileges that are essential, please mark this, Malaj, for undertaking their legislative functions. An alleged act of destruction of public property within the House by the members to lodge the protest against the presentation of the budget cannot be regarded as essential for exercising the legislative functions. The actions of the members have trodden past the line of constitutional means and is thus not covered by the privileges guaranteed under the Constitution. So this is a test which I would comment for the fact that it has to be essential for undertaking the legislative functions. It's a better test than the test of proximity of in time or that the vote or speech is already completed. The question is only whether while giving that speech or casting that vote, was it a part of the essential legislative function which was done? If it was done, you have the protection. But if there is any interference with that flow of what the wheels of parliament or legislature are undertaking, if there is any interference of any sort, that cloak cannot come to protect. That protection would not be available. I'll just finally say one thing. There is an article by Professor Shubhankar Dam, which is annexed. I'm sorry.
Ordinance. He's written a book on ordinance.
He's written a book on
I in
ordinance.
fact cited it, I think, in my judgment in Krishna Kumar Singh, I think.
Yes. So he in fact has written a series of very well researched articles, including on the constitutional right to vote and whether it's a constitutional right or not, etc. But this one is specifically with reference to, it makes for interesting reading, especially I think if you're a judge, because he talks in like how many writers write about philosophies in the US. Same way he talks about Narasimha Rao and Rajaram Pal and the philosophies which attended them.
Where is that article?
See the page numbers, it's 1951 of volume 6, 1951 to 1953. I know, I'm just taking the relevant portion. 1951 to 1953 is where Narasimha Rao is discussed. And he says how perhaps the Supreme Court had a revisiting of its philosophy between Narasimha Rao and between Rajaram Pal. But I'm done. I would just believe that the minority lays down the correct law. I'm grateful for a patient hearing. 2 points of gratitude quickly. I'm sorry. 2 points of quick gratitude. One, I have a very able team of lawyers who've put all of this together. I'm some of their parts. So Tanya, Vishal, Janvi, Trisha, Shivani and Aditi. And Mr. Ramachandran, because he repeatedly stands in this court and takes completely difficult cases and somehow makes arguments out of them. He's an example to all of us at Tabam. I'm most grateful.
I suppose the second part.
Yes, my lord.
Yesterday, he did a very good job of
With it.
in a